It's a huge diplomatic victory for India.
भारत को मुंह की खानी पड़ी है और पाकिस्तान की फतह सामने आ चुकी है।
The Kulbushan Jadhav judgment has three aspects. First, the issue of jurisdiction. Briefly, it's important to understand what India and Pakistan had argued vis-a-vis jurisdiction. India relied on Article 1 of the optional protocol concerning compulsory settlement of disputes to the Vienna Convention on Consular Relations. India argued that said jurisdiction was invoked due to a dispute arising from interpretation of Article 36 of the VCCR. पाकिस्तान ने इस मौक़िफ़ को चैलेंज करते हुए ये कहा कि आर्टिकल 36 VCCR का वायलेट नहीं हुआ क्योंकि यादव जासूस है और इसलिए ICJ का इख्तियार सिर्फ आर्टिकल 36(2) ICJ स्टैट्यूट के तहत इन्वोक किया जा सकता है। ये ज़रूरी है क्योंकि पाकिस्तान ने ये आर्ग्यू किया कि हमारी आर्टिकल 36(2) के तहत डिक्लेरेशन ICJ को ये इख्तियार नहीं देता कि वो उन मामलात में फ़ैसले दे जहां पाकिस्तान की नेशनल सिक्योरिटी के कंसर्न्स हों। इससे बढ़कर पाकिस्तान ने ये कहा कि 2008 का बायलैटरल एग्रीमेंट पाकिस्तान और इंडिया के दरमियान इस चीज़ को तस्लीम करता है कि पाकिस्तान और इंडिया के बीच कॉन्सुलर एक्सेस डिनाई किया जा सकता है अगर कोई सियासी या सिक्योरिटी ग्राउंड्स हों डिनाइल के लिए। इन अदर वर्ड्स, पाकिस्तान की ये कंटेंशन थी कि VCCR अप्लाई नहीं करता और कि 2008 की बायलैटरल एग्रीमेंट ने VCCR की ऑब्लिगेशंस इंडिया और पाकिस्तान के हद तक तब्दील कर दी। तो इस पहले सवाल पर ICJ ने अपनी जुरिस्डिक्शन को एक्सेप्ट किया।
Now, what did India actually ask the court? India said, firstly, to declare the military court, their decision and their sentence to be in violation of international law. Secondly, they asked that the decision of the military court be annulled and that Kulbushan Jadhav then be released and given safe passage to India. They said if he is not to be released, then the alternative would be that a retrial would take place in a civilian court for Mr. Jadhav. What the court did was that it granted India review and reconsideration and did not allow the release or annulment of the decision. Now, what is to happen in this case? Well, review and reconsideration essentially means that a Pakistani court will review the case and assess whether the denial of consular access actually prejudiced Kulbushan Jadhav's trial. This will be done through domestic mechanisms within Pakistan. Interestingly enough, in this case, both countries are claiming victory. But what you really have to see here is how do you gauge victory? If you gauge victory by seeing how many of your demands are met, then I don't think any of the countries will be satisfied. If you look at India's contentions, they wanted annulment of the decision, release of Kulbushan Jadhav. They did not get those. And in fact, what they did get, review and reconsideration, they themselves had stated would be highly inadequate in this case. And therefore, for them, that would seem like a serious loss. For Pakistan, what we need to see is that the court has declared that Pakistan's actions were in violation of international law. However, the violation that took place and the remedy that they've suggested is a domestic remedy that Pakistani courts will utilize.
In order to understand what's going to happen in the future, we need to look back into the ICJ's history and understand how states have responded to verdicts against them. So for instance, in 1985, when the Nicaragua judgment was given against the US withdrew its recognition of the compulsory jurisdiction of the ICJ, which it had originally accepted. Similarly, in 2005, when further judgments came against the US withdrew from the optional protocol to the VCCR, the same convention that is being considered in the Yadav case. So there are options for both states, for instance, to withdraw recognition of the jurisdiction of the court as some sort of a face-saving measure, though it's debatable how much good that would do. The most feasible option in this situation is for Pakistan to grant Yadav consular access and review the sentence in line with its own domestic procedures as the ICJ has ordered.